Okay, hello everybody. Let's get started. I think we've got a couple of people still making their way in, so we'll kick things off. I think that the first minute or two is just some introductions and things anyway. So we'll get going before the main sort of meat of the content. So hello, welcome. This is a webinar brought to you by the people of Verif, your guide to AI compliance in 2025. Some of the things we're going to be covering today, actually, a little brief introduction by me. Then we're going to get really into sort of the meat and the bones of things, which is compliance requirements with a specific focus on the EU AI Act. I think I'll explain a little bit in a minute about sort of the geographical sort of ramifications of that, but it's really going to be digging into what the Act is, some of the implications, I guess, for businesses both within the EU and those that are based elsewhere but that trade here. And then the third section is going to be what we're calling our road to compliance. And this is really some sort of some practical tips, some takeaways, some guidance on how businesses can adapt to this regulations that are coming up. And then we wrap up with a summary and Q&A. And I think just a point to make on that, actually, the Q&A piece on your screen, if you would like to submit a question, it's just below the slides. So you just type a question in there. It will come through to us directly. We'll see them as we go. I think if it's about something that is relevant to what we're talking about, I'll try and work it in. We do have a section at the end as the agenda sort of demonstrates here. But so anything you have at all. And I think even if it's about sort of other areas and things like that, those questions are always useful for us. We might not get to cover them today. We will have one of our experts sort of get back to you on it, but it also gives us some real guidance about what we can do with our kind of webinar roadmap. If there's other jurisdictions you'd like us to cover, for example, and things like that. And our plan for the year is fairly sort of flexible. And if there's a sort of real big demand from our audience on what it is that we want to be talking about, then we can always work that in. So just by way of introductions then, just to get us started, my name is Chris Hooper. I'm Director of Brand here at Verif, and I've just noticed that my headshot has a picture of me wearing a Verif t-shirt, and I'm actually wearing a Verif sweatshirt right now. So if there was any doubt who I worked for, I think that's been extinguished pretty quickly. My role here is to deal with our thought leadership. So I produce all of our sort of reports, all our content, all our white papers, specifically into fraud and increasingly so into some compliance and regulations, actually. So there's a great deal of sort of thought leadership that's available to you here, some of which you can download on your screen, actually. If you sort of play around with some of the areas that are around on the platform that we're working on today, you can see some of our reports and so on. I should just say that I am stepping in for one of my colleagues today. Alexander Suman was due to host this. He's one of our legal experts here. He's sadly fallen down with a bug this week, and so Alex, I know that you'll be listening on the on-demand version here. So get well soon, and I hope you're back fighting fit sooner than ever. But in Alexander's absence, fear not, you are in safe hands, because I have sort of two super experts with me joining me today. The first of whom is Tia Park, who is an attorney at law at Neward Law Firm. And specializes in technology law. Tia is a certified information privacy professional. She has helped both private and public sector clients in establishing compliance with the EU's General Data Protection Regulation. Is also a lecturer in topics related to data protection and AI-related legal aspects too. And her special interest is the use of technology for ensuring compliance. And then we have Jeremy Jolie, who is the co-founder and CPO of Spectre, where he leads product development focused on creating tools that make compliance easier for businesses. With years of experience in banking and a background in data engineering, Jeremy has deep expertise in translating complex regulatory requirements into practical user-friendly solutions. And before founding Spectre, Jeremy was the lead on the product team at HelloFlow, a no-code platform for client onboarding, which was later acquired by Trulio. I'm somewhat offended that Jeremy has left out of his bio that he was a recent guest on the Verif Voices podcast, actually, with me. That's another channel that we have here. It's I think we're up to about 42 episodes now, actually. If you are looking to find a new podcast for your rotation, I highly recommend it. It's we explore fraud, we explore compliance, technology, innovation, and kind of everything in between, really. So if you're looking for something that is on this subject, the episode with Jeremy was one of the best ones we've done. It's really, really good. And just go onto the podcast platform of choice that you like, type in Verif Voices, and you'll be able to find it there. Okay, so Tia and Jeremy, thank you for both joining us. I think I appreciate that you've given up the time to do so. Let's just set things up with a couple of sort of more general questions, just to warm things up, I suppose. Tia, I'll start with you. How does AI sort of work in your daily work and professional life? How does it sort of intersect in there? And I guess where do you personally see AI as bringing the most value to the world?
Thank you. So as I was introduced, I am a practicing sworn attorney, focusing mostly on technology law, including data protection law. And we are eager to make use of different AI-related tools in our work as lawyers to make our work more efficient. What I see personally as very interesting and what could be a trend in the very near future is that as AI is developing very rapidly and also other technologies are developing quite rapidly, such as no-code, low-code tools. Many of the no-code, low-code tools already have AI functionalities embedded in them as well. I can kind of anticipate a trend that as lawyers, when we are providing legal services, maybe in the future we can even develop some legal tech solutions for our clients on our own, which is quite interesting. And we are kind of stepping into that in Njord as well a little bit. And otherwise, just making the daily work and the more mundane, burdensome tasks easier for us and using AI to automate them where we can so that we can focus on the more complex legal questions for our clients.
Absolutely, and fully concur with all of that too. I think that Verif is an AI-driven company, and we're certainly seeing that. I think that there's the speed with which we can innovate, the speed with which we can sort of bring new products to market and so on is increasing all the time. So decreasing all the time. Sorry, and it's remarkable really the amount of work that we can do. Jeremy, welcome to you too. I'd like to bring you in here, and I'll turn that question on its head for you. I think what do you think are some of the main challenges related to artificial intelligence?
Yeah, there are quite a lot. Although since the field is evolving so fast, those issues are often being addressed even before sometimes we realize they were there. But I can mention a few. So for example, it's quite difficult sometimes to have transparency about what LLMs or AI models will be generating. So, for example, at Spectre, we've had deployed some AI models. It's difficult to do software today, to be a software company without doing AI. So, yeah, of course, at Spectre, we're deploying some AI solutions for our users, and it's been sometimes tricky to be able to reproduce the same sort of output, even if we have the identical input together, because we don't control the model. So there's a lot of system prompt that goes into place, and of course, models are getting better and better to be more and more transparent, to organize their chain of thoughts, and being able us users to look under the hood a little bit. But it's still kind of a bit of a challenge, I would say. Then I could mention also safety. So harmful, biased content. So, for example, DeepSeek that has been shaking the world of AI lately. If you ask about the Tiananmen Square, you're gonna get ghosted, right? So it's a bit biased in that sense. And in the term of safety, you have also hallucination. It's been known as some funny examples of AI model completely inventing facts, but also, as I said, the big actors, ChatGPT, Gemini, all these big LLMs have more and more sophistication to avoid these problems. But the main one, and the one I think we're going to talk about during this webinar the most, is the liability. So as software users and deployers and people that are building these models, there's like a huge chain of users that are embedding AI softwares and AI model in the different solutions. So it's going to become more and more difficult to understand who's liable when something goes wrong, right? So as a quick example, like imagine an investment firm that has a AI model for stock analysis, another one for investor sentiment, and another predictive model for stock price movement, for example, right? Then they automatically execute a trading strategy with another AI model. So in order like you have 4 or 5 AI models, and then if the users of the clients of this investment firm start losing money, who's liable? If they're using models from a lot of different vendors, who's liable for what went wrong, right? So it's going to become pretty difficult in that sense. And I think the EU AI Act is trying to cover that, and I think we're going to talk about this a bit more.
Yeah, absolutely, and I'm certainly glad that you finished on that one. It segues very well into the next section that we want to talk about, actually. And this is that. Yeah, I just want to make it be really clear, super clear to the audience here about what it is that we are going to be talking about. Regulation is obviously it's a global business. I think most businesses these days are digital. Most businesses are global. But when we were sort of first looking at putting the content together for this webinar, we sort of thought that it'd be really good to sort of do a global summary, but that really is just not possible. We'd be here for about 5 hours, I think, and there's so many nuances between various regions and so on. So what we've decided to do is focus squarely on the EU AI Act, which is, to prove that, we've written it in big letters on this slide by itself here. But as Jeremy mentioned there's that kind of intersection between this act and lots of other EU legislation as well. GDPR is a really good example where I think businesses really need to be aware of what's happening, just so they don't fall foul of it. I think is the main point here. Tia, would you mind giving us a little bit of a very sort of high-level overview of this piece of legislation? And I'm thinking maybe some of the sort of the key definitions, the sort of key compliance obligations, maybe sort of the risk categories, and sort of maybe this the key terminology, I guess, that people need to know around this piece of legislation.
Sure. Like most EU legal acts which regulate technology-related topics, the act is it's a long one. It has many articles. What maybe distinguishes this particular legal act from some other ones which are quite important in the field of technology, like the GDPR, for example, that this one really has a long list of definitions. Actually, it kind of stands out. It also kind of stands out that the legislator has tried to define a lot around the concept of AI for the purpose of this act and regulating the use of AI. So not going into too much detail, because this is a webinar and we could always thoroughly analyze terms in legal acts, but the most important ones we have gathered here on this slide, because it's important to understand, I think, in the context of this legal act, if you are developing an AI system, or if you plan to use an AI system in your own company, it's important to understand what kind of actor you are in the context of this legal act. The legal act, first of all, of course, defines what is an AI system. The definition for an AI system is very broad. So definitely going to spark a lot of discussion and analysis around it. An AI system is a machine-based system with various degrees of autonomy, able to adapt itself after deployment, and is able to, with the input it receives, perform a variety of different tasks. And the most important part of this definition is that the AI system can influence the physical or virtual environments around us. So in addition to that, now when we're talking about companies and institutions using AI, then it's important to distinguish between a provider, importer, deployer. A provider is, for example, a company who develops an AI system. Then the deployer is a company who, for example, purchases an AI system or a subscription of an AI service, including an AI system. And if I start to use this AI system in my company, then I'm a deployer of an AI system in the meaning of the act. An importer of an AI system is a company who basically imports to the EU market an AI system which has been developed outside of the EU. So that is actually pretty clear. And then also I would highlight, because I think this can also spark some problems and discussions, and is very much related to the liability issues which have been mentioned. A distributor is a natural or legal person who then sells the AI system which previously has been imported to the EU market by the importer. And placing on the market, because many AI systems actually are, they have been developed outside of the EU. So placing on the market, this is an important term. It triggers several obligations from the Act, and this is the first making available of the AI system on the EU's market. So this is kind of like some of the most important terms to understand.
Interesting.
And now,
so I was just going to ask, just on that point, actually, around sort of jurisdiction and where companies originate from. It may be just worth a quick explanation of that, because I think it's obviously organisations that are based in the EU, this applies, but is it also for organisations that are based elsewhere but trade here? And how much do those organisations need to care about this, I suppose, is the big question.
Yes, this is a big question, because organizations who are developing AI systems outside of the EU, for example, in North America or Asia or elsewhere, they also need definitely to care about the Act and think about the Act. This is because according to the Act, if you have developed an AI system and you are providing it to your users who are in the EU, then you must comply with the Act. And regardless of whether your company is located or established in the EU, this does not matter at all. And secondly, there's also a clause in the Act saying that if the AI system developed by you outside of the EU, if the output of this AI system is used in the EU, then you also must comply. So it kind of has a very broad reach globally, actually, the Act.
Yeah, it's really interesting, and I think, you know, as I say, when we were looking at the content for this webinar, it's sort of, you know, it became apparent quite quickly that there was that the reach was much bigger than we thought originally when we were first planning it. So that's really good to hear.
It's kind of like, I would say it's a bit similar to the GDPR in this sense. The GDPR also sets rules about the processing of personal data in the EU. But if you're a company and you're processing EU residents' personal data when providing services, you need to follow the GDPR. So it's basically the same thing in that aspect.
Yeah, absolutely. Actually, Jeremy, just to bring you here in again, so considering what was, you know, just been laid out by Tia there, what do you see as the main issues here, or where companies would need to take the biggest leaps forward, I suppose, when it comes to sort of staying compliant?
Yeah, so it sounds like, based on this regulation, that even companies that don't build their own AI model, but integrate LLMs, for example, right, via their cloud provider, or so LLM models like OpenAI or Gemini, into their software, they will have to be compliant. So for all, that's funny, because the regulation is very vague in terms of definition. So it's like machine-based. That can be a lot of different things. So what's going to be interesting in the future is going to be like, what's the interpretation of that vague definition in the next 6 months, in 2025, basically, and I know how that's going to impact people using like companies using AI. But yeah, I would say the classification, of course, of those models that are AI tools that are being used across the different industries. Because based on that, as Tia said, based on that classification, risk classification, if you're high risk, you're going to have a lot of documentation to do. You're going to have a lot of transparency and explainability to do. You're going to have to disclose the AI use very, very clearly, expose the limitation. So you're going to inform your users that something is generated by AI, for example. Even if it's just a chatbot, you're going to have to say this has been generated by AI. Making it very clear. You're going to have to explain the role of AI in your solutions. So again, documentation, answering customer questions. You're going to have to reference the API, the AI provider's documentation. So if you're using OpenAI from like a ChatGPT from OpenAI, you're going to have to reference their documentation and maybe understand it for your users, because it's your role to make sure that you're compliant, even though you're not developing your own LLM model. So yeah, there's going to be a lot of overhead on the companies that are deploying these tools, I think.
Yeah, absolutely. I love this. It seems to sort of come down to sort of clarity and transparency to a certain extent. I think my next question, actually, staying with you, Jeremy, on this one is everything in the AI Act seems to sort of stem from the AI system and the definition of that Tia just gave us. I think we've got a next slide actually, which gives a bit more of this, and there's a bit more. I'm not suggesting we go through all of this because there's a lot here, but I think my question is, while I leave this slide on screen for people to read. Jeremy, what do you think this definition is clear and useful? First of all, I think that's the first question. But do you have any practical recommendations for companies on how to tackle some of the issues that sort of come out of this?
Yeah, I think we're gonna go through a bit more guidance as well a bit later. But yeah, and I don't think the definition is very clear and useful. I mean, from product business perspective, I feel like it can cover a lot of deep learning machine models deep learning models and machine learning models that have been around in finance for 20 years now, and I don't see why we would retroactively do some regulation on those. But as I said earlier, the EU might decide that yes, they fall under this regulation, and now we need to document and make sure that we are doing things according to the regulation. But again, with GDPR, as Thea said, it's been around for a while, and there's a lot of stuff that has been happening. But in terms of and I would say let's wait and see in terms of the interpretation again, because you might not need to do all sort of documentation and transparency, explainability for those models that don't need to be. And then regarding, I don't know if we wanted to go through the guidance right now, or should we?
No, let's come back to that in a minute, because I think that's we'll get into that properly towards the end of the session. I think there's still a bit more to explore here, and you did actually mention GDPR, which is one of the key things. But I think before we get on to that, Tia, there's a couple of key dates that I think people should know about. You sort of flagged some of these as being particularly useful to people, and I noticed that one of them has actually passed. So I know in the world of sort of compliance, sometimes there's a little bit of a lag and that kind of thing. But do you want to just explain what these dates, what the relevance of them is, and certainly that first one there, and what people need to know about this?
Yeah. So the first one is about the clauses in the AI Act about prohibited use cases. So this has entered into force. There are some use cases of AI which are strictly forbidden. For example, the use of AI in facial recognition and grouping people according to that. It's prohibited, completely prohibited. It's not even high risk. It's forbidden at all to use AI systems in investigating and bringing people to be liable for criminal offenses, and also the so-called social scoring according to the AI Act is prohibited as well. Then the other significant dates, basically, when we're talking about the AI Act, then one aspect which kind of maybe can calm us down a little bit, calm the companies down who are fearful of the strict obligations arising from this act, is the fact that when you actually look at the articles in the AI Act, most of the restrictive obligations stipulated in the AI Act, which were also named on the previous slide, these actually apply to high-risk AI systems. And sort of limited risk AI systems fall out of the scope of these strict obligations. And now these important dates mark the step-by-step becoming of applicable of the obligations which are meant for high-risk AI systems exclusively. And therefore, it is important to actually understand whether your company or whether the service provided by you constitutes a high-risk AI system or not. To put it shortly, if you're not dealing with high-risk AI systems, you can forget about the most restrictive obligations in the AI Act, fortunately.
And I think we've actually got a couple of slides here which go into that. Certainly the element of the risk part here. Would you mind just sort of elaborating on that a little bit? I think that we can so people are understanding of what these obligations are. Should they fall under that categorization?
Yes, so a high-risk AI system, first of all, when trying to explain it as simply as possible, like a normal human being, not as a lawyer, then high-risk AI systems are the ones which, when we're using them, they can really bring harm to other people. They can significantly and negatively impact the rights and interests of other natural persons. So some simple examples of high-risk AI systems. For example, when AI systems are used in making decisions in the court, when we are using AI to determine whether a person can apply for a loan from a bank or is applicable to get credit, when we are using AI systems in education. For example, if we use AI to determine which students should get admitted to university, when we are using AI to determine whether a specific employee should get a promotion or not. So these are some simple examples about high-risk AI use cases. Then also what is considered as a high-risk AI is when we're talking about dangerous products and machinery, for example, lifts, vehicles, toys, which are already protected by different laws in the EU concerning product liability. And if we are now embedding AI into those products, then according to the Act, this is by default considered as a high-risk AI use case. And now these companies, these products, these services, they must follow the obligations which are stipulated for high-risk AI systems in the Act.
I see. And just to extend that sort of definition out, we've got a slide on screen now talking about general purpose AI models as well, which I guess is a slightly different categorization. Do you want to just talk a little bit about that?
Yeah, that is a different categorization. Basically, what is meant by general purpose AI systems are the AI solutions which we are using every day now, like ChatGPT, Gemini, and others, which are sort of like meant for a very wide variety of tasks. They can generate text, audio, visuals, and they have their own articles in the Act. They are not considered as high risk by default at all. What is most significant about the use of general purpose AI models is that it is important to disclose that some kind of either text, visual, or audio has been generated by a general purpose AI model. That's like the main obligation is to be transparent.
Sure. I'm just going to skip back to this one slide. Jeremy, I think you had a comment on this before. We sort of I overlooked it. Was just sticking with Tia. What did you have something you wanted to add on this one?
Not exactly. I just wanted to make sure that since we were talking about this general purpose AI models, yeah. So,
I see. Okay, gotcha. And I think it's worth I think bringing in another issue to this as well, which we've mentioned a couple of times, which is around the sort of the intersection, I suppose, of this act with other EU legislation, which is, and I'm specifically thinking about kind of GDPR on this, I suppose. Obviously, that comes with its own risk. I mean, Jeremy, this is something. Where do you see companies can sort of optimize, or which solutions can they explore to use less personal data for their service development, sort of minimize that privacy risk?
Yeah, so I don't think this EU AI Act is bringing a lot of new regulation in terms of privacy of data that GDPR didn't already cover. So that's why I was listing here like the privacy enhancing technologies. They basically have been around for quite a while. So something like anonymization of data, pseudonymization of the data. That's something companies using a lot today. I don't want to use too much time on this because it's not really the core, but I mean, encryption data, and also something that's new with AI today is that you can generate synthetic data. So instead of, if you have some AI model that you want to train for a new feature that you're releasing, instead of using your employees' personal data, your client's personal data, that you would need to get consent for, maybe change the contract so that your new customers give you access to their personal data so you can train your models. Today, you can just generate synthetic data with another AI model, and you don't need to do that, right? And that's what AI is LLM models are doing. Basically, they're just reading the internet to start with, training the models, and then generating data from that. So they don't really use any recognizable personal data. And then the other points I wanted to make is that, yeah, there's an alignment with the GDPR. So what's probably going to come out of this regulation is that you're going to need to have align a use case, and so you have a lawful basis to use AI for a particular use case, a particular feature on your platform, on your app, that has a legitimate interest for your your users, basically, right? And you're going to have to do to conduct some DPIAs in order to validate the compliance of what you're doing. And again, GDPR also tells us if you can prioritize non-personal data, so there's not really an issue there. So yeah, that's just the point I wanted to make on this.
Yeah, and Tia, just what's your take on this too? Is there kind of what are the main things to consider when sort of training models with sort of copyright protected data or confidential, business secrets, for example, or something like that?
Mm-hmm. Yeah. So first of all, just to second Jeremiah, that regarding the processing of personal data, the AI Act does not set any new rules. Basically, you just need to follow the GDPR, but it becomes more complex and difficult, unfortunately. And it's possible and very likely that companies need to conduct more data protection impact assessments according to the GDPR. Now, regarding copyright protected data and confidential data, which we sometimes want to submit to the AI model to get an output, this is a difficult case. My own experience with our clients, for example, shows that it's usually easier for a person who is training the AI or just using the AI for output to understand that you are processing personal data, your employees or clients' personal data, because it's related to a natural person. However, not all data is personal data. Trade secrets, companies' financial data, companies' strategic documents, these can be just confidential data. And often people don't recognize that there are some obligations and NDAs, some confidentiality agreements behind those. So you need to map where does this data come from? Is it related to some kind of obligation for you? And can you actually use this data for the AI? And if you give it to the AI, so to say, does the AI itself operate like in a closed sandbox? Because you need to ensure that the data is not taken and given away to another company by the company behind the AI system.
I see. Yeah, a lot of this is kind of building out best practice, I suppose, isn't it? And I think that a lot of that comes in time as well, as the Act becomes more apparent and the definitions become more clarified and things like that. Let's move into the sort of the road to compliance section of this, because I think we've got some guidelines to sort of share with people. Jeremy, do you want to kick us off on these? I think what do you think companies need to do next? Essentially, what's the sort of the next step from this, and where do they need to focus, I suppose, and a follow-up question to it is, where do you think more guidance is needed, if at all?
Yeah, could you go back to the previous slide?
Sure.
That's the one where we basically sort of sum up a lot of the stuff we've already discussed. So, yeah, I think the first really important thing to do is invest in some sort of auditing in order to define if there's any high-risk AI model, AI tool that you're using. You want to avoid over or under compliance, of course. So as Tia was saying, if you're a bank and you have an AI tool that is just a chatbot to replace your FAQ, that's probably not going to be high risk. But if you have an AI tool that does some credit scoring or takes the decision for you to give a loan or not give a loan to a customer, that's probably going to be a AI, and that's where most of the obligation, as Tia said, lie. So that's probably the most important thing. Then we've been talking also about the GDPR AI versus AI overlap, so I don't want to really repeat that. But then there's an interesting aspect is that the EU AI Act is saying is like the human oversight. So there's this sentence of meaningful intervention. So you can mitigate your risk or like your being more compliant if you just have this idea of like having a human in the loop oversight for critical AI decision. And that's interesting because what does that really mean? Does that mean that you're going to have a new department of AI compliance. You're going to have the compliance department in your company is going to have to basically jump in with product decisions. This is basically the way I see it, a bit of a new area where it's going to be needed for training with people so they understand the potential output of the AI systems. It's going to be a new type of process that don't really exist today. And then there's the third-party liability. We've talked about this again. There's going to be some work to do. So again, why not appoint an AI compliance officer, right? Because these in the next year or in the next 2 years, all this is going to crystallize. And as Thea said, like the obligations that are going to come as we saw with the dates, they're going to come. So you're going to have to define and to decide, am I liable if I'm doing this tool and this feature for my users? And something, so the general AI rules, we've talked about it, and the cross-border data as well, we've talked about it. It's like, it's really interesting. Like if you're a bank, for example, and you're doing, you have an LLM, you're using an LLM a tool in the US for something, you're using another AI tool in HR and recruitment in India, and you're using transaction monitoring for your transaction tool in China. Like you're gonna be in trouble, right? There's gonna be a lot of work for you to make sure you're compliant if you're doing that. So it's gonna be interesting.
There's an interesting question in the Q&A chat, actually, which I'll put to you, Jeremy. I think it's just about kind of your opinion on this, really. But do you feel like this act over-regulates the field in a way that could possibly hinder development of the usage of AI in the EU? I mean, it's obviously just your personal opinion on this, because I think it's a lot of this remains to be seen, I suppose. But what's your take on that?
Yeah, totally. I mean, I totally think it's. I mean, we're very good in the EU to come up with regulation. The rest of the world is not really apart from this. And my perspective is, product and business and making good solutions for users, right? We need to protect them, of course. But the rest of the world, in this particular area, the rest of the world is not really slowed down by heavy regulation. And we're already lagging behind. Like, there's not really any big AI model that is performing well in the EU yet. We have Mistral, but that's more or less it. So I totally would say that it's a lot of regulation for the continent that is the least innovative so far.
Yeah, it's interesting. Okay, let's skip on to some of the guidelines then. I think we sort of flashed this slide up before, but I don't know if you want to kind of run us through some of these here and really sort of I guess give your take on how businesses can make sure that they're adapting to this future that Jeremy's just outlined there.
Yeah, so the AI Act is very complex. The terms are very broad. The ones which we highlighted in one of the previous slides are just this is just a small selection of them. Basically, what I can see already is that the applicability of this new EU Act will bring a lot of work to compliance officers, in-house lawyers, and lawyers in general. There are some very good recent guidelines which help companies to understand what the provisions and the sentences in the legal act actually mean. And some of these are very recent. So, for example, there's a guideline about the definition of an AI system, because this is, well, the most vague and broad term, I would say, in the Act. So I would really recommend to study this guideline if you're wondering whether the product or the service offered by your company, whether it or part of it constitutes as an AI system or not. Then there's the document called Living Repository of AI Literacy Practices. It basically compiles kind of like interview style chapters where different organizations share their best practices about implementing AI and creating the ethical and legal rules about it. And then there's also a good recent guideline from the European Data Protection Board, which now is about processing of personal data when using AI, and it highlights how to tackle GDPR issues when you're using personal data in AI systems. Because as I said previously, the AI Act itself does not regulate processing of personal data, just the GDPR applies like it has. But it's difficult to understand how the use of AI can comply with, for example, purpose limitation principle in the GDPR and data minimization principle and other principles.
Yeah, that makes perfect sense. And I've actually there's a question in the chat that we're going to put to you here, Tia. I think a lot of this is. Thank you for outlining that, by the way. And I should just say that these slides will be shared with the recording that comes to you afterwards, so you'll have a chance to look through them. We'll include some links to these because they're quite tricky to find, but we'll include the links in the email as well, so you'll be able to find all of these resources available to you. The question that's come in though, Tia, I think is what level of additional responsibility will this have on compliance officers? I think that it seems to be a sort of an undefinable amount, but what's your take on it?
Well, if the compliance officer is working in a company who is actually providing an AI-based product for its clients, then this new act and compliance with it, and especially if this product is considered a high-risk AI system, then this act will play a significant role in this compliance officer's daily work, because complying with all of the articles which are directed at the high-risk AI systems, there's many of them, and these concern technical documentation, data quality, transparency, ensuring human oversight and logging, for example. So like developing these procedures and the documentation is a huge part. And I think it's quite similar to just ensuring GDPR compliance. And this is why we have DPOs and sometimes specific people dedicated for GDPR compliance. So this is like a new huge bunch of obligations. So a significant part.
Yeah, and Jeremy, I'll put that same questions to you as well, because obviously, I mean, Spectre, the company that you run, I think it's it creates tools and software that enables, it helps people with compliance and makes it easier. Do you sort of, what's your take on this? Because I think you'll be coming from a very different angle.
Yeah, but I think it's right that what Ted did is like it really depends on what the company you're working for does, right? If you're the one building the AI model and deploying it, it's one thing. If you're one that is using something that already exists for a variety of applications, it also depends, right? If your application is just a chatbot to replace a Q&A, again, that's not really high risk. But if you using this to score your clients for very important decision, yeah, then you're gonna have a lot of documentation to be able to do and so that you can prove to the regulator that what you're doing is completely transparent and you can explain what's happening. I think that's the main thing that needs to be covered, is that you can explain what your tool does, right? Because a typical rule-based engine, in order to take a decision on a loan, for example, it would be pretty easy, right? You're gonna have some if and else rules, and you're gonna be able to document that, like do the technical documentation. Based on these rules, the client has access to a loan or not, right? With the AI, it's much more difficult to have this level of transparency. So you're gonna have like to explain everything that you're doing in order to mitigate that there's not any harmful decisions that are being taken by the AI towards your customers, that you're taking all sort of like actions to make sure that you've been training the model, you've been testing it, your users are actually aware that this exists. There's limitation to it, and as we said, like have a human in the loop for oversight. Yeah, all these sort of things, right?
Yeah, absolutely, absolutely. I think we're approaching end of time here. We've only got 2 minutes left, but I'm going to combine a couple of questions from the Q&A here, and I think that the first one is how should companies in the EU prepare for compliance with the AI Act? And the second question that I'm going to mix with it is, are there sort of notable timelines that we should be working to in terms of, is there anything we need to watch out for, and when do we need to have it done by? So, Tia, do you want to take that one? That feels like a question for you.
Yeah, sure. So first of all, just a quick note about the previous question, which is related to the answer to the new question. Okay. I would also just highlight that the AI Act and compliance with the Act is very nuanced. So I said previously that companies who are already providing high-risk AI system products on the market, they definitely need to comply and they have lots of obligations. However, since AI systems are developing very rapidly, and in several companies, different parts of the company really want to start implementing AI themselves. What I want to say is that things can, change in the life cycle of a company, of a product, of a service. You might not be selling high-risk AI systems on the market today, but you could be doing that tomorrow, or you could be deploying, for example, an AI system in your HR department tomorrow. Then it could be high risk already. So it's very nuanced. And basically, to conclude this, I think all legal and compliance officers need to be aware of this act and need to monitor whether it affects them. Now, to the question, how to prepare for compliance with the AI Act. I would start by mapping where does the company use AI at the moment, all the different AI solutions, the different AI functionalities which are have been added to existing solutions. So where are we using AI and for which purposes? Then determining whether these constitute as AI systems in the meaning of the Act, whether we are using or developing any high-risk AI systems, and then determining which obligations from the Act actually apply to us. So basically, these are the steps I would take, and I would just start by leaving the legal act aside for a moment and just mapping what we are doing with AI. Where are we using it?
Absolutely. And just that second part of the question is about sort of timelines and things like that. How quickly do people need to be doing this, I suppose, is the main takeaway.
Yeah, so the Act becomes fully applicable in 2027. Mm-hmm. So then it's fully applicable. There's an important deadline this August concerning high-risk AI systems. So if you kind of have this in mind that your company is dealing with the high-risk AI systems, you should look into the Act already. Also, as it was with the GDPR, it's kind of difficult at the moment to understand what exactly do you need to do to be compliant. Do you need to carry out an audit? Do you need to draft some kind of analysis? Some parts of the Act directly say that you need, for example, technical documentation. This is easy. There's an annex in the AI Act which tells you how to draft technical documentation. But this means that it's important to follow the recent guidelines, which we refer to as well. They help you to understand what do you need to draft then, what do you need to have ready to say to the supervisory authority that you are compliant.
Yeah, absolutely. I think that's often the way with these things with a new piece of legislation, isn't it? I think that guidance is out there, but I would act sooner rather than later if I were you, because it's one of those things that these timelines just come around all of a sudden. It's 2026 and we're sort of right there. So thanks. That's a really good point to end things on. Actually, I think we're just about just gone over time actually. So thanks everybody for listening. That was hopefully a really good discussion. There was loads of questions in the chat that we didn't get to, so that usually indicates that there's a lot of engagement with you guys. And and we'll certainly get to those in the emails that we send out to you as well. So we know who the questions come from, so we have obviously your email addresses when you signed up, so we can reply to you there. So thanks everybody. Join us again in the future for we've got a whole sort of host of these coming up about our regulations and compliance. And if you have questions about it, if you're worried, there is guidance available. You'll find it in the slides, but also reach out to some, your account manager at Verif or to one of our experts here, and we'll be able to guide you as well. And then finally, just to say thank you to Tia and Jeremy. That was really good. I know, like I said at the beginning, I know that you're both incredibly busy, so thank you for giving us your time today.
Thank you, Chris.
So much.
No worries. Okay,
Bye.
thanks everybody for listening, and we'll see you next time. Goodbye.